So we will see Hindu law. So Hindu law, first unit, we have the concept of dharma. We have sources of Hindu law and schools of Hindu law. So schools of Hindu law is something which is like a big topic, you can say, from unit 1. Okay, so we'll start with the concept of dharma, and after that we'll move to the sources of Hindu law. So the concept of dharma under Hindu law. According to Hindu jurisprudence, dharma, what is dharma? It means something which is similar to, we can say, duties that we have. Okay, as such, we cannot say that dharma is having some, like proper English translation to it. We don't have that. But it can be considered something similar to what different duties we are having. So this could mean either religious duties or even some social, legal, or spiritual duties. There will be different duties that one person is having. Plus, depending on what the person, like in earlier times, if we say, depending on the social status, depending on the caste, we used to have different duties. Those also would be included. Okay, so or depending on age of a person, also we would have different duties. All of that can be included under this concept of dharma. Okay, so as such, you can consider it something similar to duties that we have. Some people also use the word to mean righteousness, which gives it a moralistic interpretation. What is right, what we should do in a certain given situation, that is also nothing but considered similar to dharma. So in a certain given situation, what a person should do, that's also nothing but similar to this concept only. Like what duties of a certain person would be in any given situation. In purely legal terms, if we consider dharma, it means nothing but justice, right? Doing justice, giving justice in a certain situation. That's also something similar to dharma. So what dharma is? It is deemed to be the highest ideal of human life. The earliest mention of this concept was in Vedic texts like Rig Veda to mean the foundation of the universe. These religious texts claim that God created life by inculcating principles of dharma into all living creatures. Therefore, salvation or moksha is the eternal dharma of humans according to Hinduism. It's something which you will also get. There is a subject called jurisprudence. Okay, there also it says that in earlier times when we were not having any laws, any rules, regulations, etc., what used to happen is that we have an internal feeling of good and bad. Okay, we have an inherent tendency of differentiating between right and wrong, even though we might not be having written rules or regulations. So in such cases, what happens is that's nothing but, again, like a concept of dharma, we can say. Okay, that what is good in a certain given situation, we try to do that, and it's something which is there inherently within us. It's not something which is taught to us or which we learn from books or something like that. Later, Hindu texts like Upanishads greatly refined the concept of dharma and made it more moralistic. Since this was the time period when nation states started evolving, dharma attained a legalistic meaning. So, gradually, what people should do, what people should not do, this religious text started explaining us what is right, what is not right, what we should do, what will be our obligations. Everything started to be mentioned in a more clear way. So we started doing that. Hindu legal codes like Manusmriti use dharma to mean religious and legal duties of a person. So Manusmriti explains in detail about what duties will be, and those duties are also nothing but similar to dharma only. In other words, dharma means the prescriptive concept as it described what people should and what people should not do. The interpretation of dharma continued, and its traces exist even in modern Hindu laws also. Like when you talk about the sources of Hindu law, There we have all these religious textbooks as well, right? So from there we can say that this concept still prevails. If you talk about modern Hindu laws, this concept is something which is not completely like gone. It still prevails in modern times as well. So it's something which explains us what we should be doing, what is our obligation, and what we should not be doing. Even Hindu epics like Ramayana, Mahabharata refer to dharma. They say that performing one's duty is the ultimate aim of every individual. Since the main function of a king is to uphold dharma, these texts often refer the king as Dharam Raja. So he will be the one who will ensure that what the duties of people are, whether they are performing it or not. Or if we talk about justice in a legal sense, also, if we say it was the king who had the obligation of ensuring or providing justice to the people. So he was the main person who was having all the obligations to ensure that dharma prevails in his kingdom. So it's a concept that emerged and was refined from many religious Hindu texts. Its meaning and scope expanded with time until it came to be associated with the ideals of law and justice. This is exactly how we understand dharma today. So, as of now, if you consider, this is more associated with the concept of justice at present day situation. So it's derived from a word dhar, which means to support, sustain, or to hold together. In the broadest sense, it includes what manages or holds together the universe itself. Only when we are performing our duties properly, only when justice prevails, we will be able to live together in a society. Right? So it is nothing but what dharma indicates. There are numerous sorts of thermos, but all include the idea of direction and are essentially guidelines of action. How we should do a certain thing, what we should do, what we should not do. It's nothing but providing us a guidance, guiding it acts like a guiding force. It can be interpreted as morality. What is morally correct? That's also would be included. Our duties or obligations, the religious duties that we have, plus law, as in providing justice, that also can be considered to be included in this word. Hindu jurisprudence takes more care over the duties more than the rights. The nature of this dharma changes from person to person. There are many duties of many people in this world, like earlier, the king's duty was to uphold law, and on the other hand, farmer's duty was to produce food, doctor's duty to cure people, lawyer's duty to fight for justice. So we have different duties, and based on person to person, duties would also change. And if you talk about the religious texts, Hindu religious texts, it gave more importance to performing our duties rather than claiming for our rights. Being a highly religious concept in nature, it is multifaceted. We have different meanings within this same word. It contains many laws and customs in a large range of subjects, which are essential and need to be followed by each and every person. For example, Manusmriti deals with religious, administrative, economic, civil, and criminal law, marriage, succession, etc. For all these different matters, it explains clearly what should happen, what we should do, what we should not do. All of that is explained there. So it's nothing but what acts as a direction, how we should do a certain thing, what should be done, what should not be done. All of that is included. Even if you look at modern laws, you would get traces of Manusmriti or other textbooks. So this concept still prevails. It's not like something which used to prevail earlier. We see its presence even today. We might consider it something similar to the laws that we have right now, or the other moral obligations. It's not just legal obligation, what moral obligations we have, that also can be considered to be a part of it. Okay, so this is the first topic we have, concept of dharma. And then talking about sources, there are sources. Say you will get this topic, okay? Sources of Hindu law, sources of law. That topic you will get in many subjects, like sources of Hindu law, sources of Muslim law, sources of law. You will get one topic in jurisprudence. Like that, sources might vary. Okay, so when we talk about sources of Hindu law, there will be some common sources, okay, for any type of law that you talk about, like customs, precedent, legislation. These are some common sources which will exist for any type of law that you talk about. But there are certain sources which are specific for some laws. Like if you talk about shrutis, smritis, all these are specific for Hindu law. But if you talk about Muslim law, then Quran would be there. If you talk about Christian law, Bible would be there. So there are some specific sources. Also, there are some general sources which are common for any type of law that we talk about. All right. So when we talk about Hindu law, its sources are divided into two types: ancient sources and modern sources. Ancient sources, as in starting point, how we got the idea that we need a law on this certain thing, or what laws should prevail. From where we got the idea, we got it from these ancient sources. And in modern times, when we already have laws almost well defined, in modern times, what are the sources? In modern times, if we need to make a law on a certain thing, what are the sources? These are the modern sources. Okay, so sources of law is also a word that have several connotations. It may be the authority which issues rules of conduct which are recognized by courts as binding. In this context, sources of law means the maker of law, from where we are getting it, from where laws are being made. It may mean the social conditions which inspire the making of law for the governance of conditions. So, whatever conditions prevailed, might be we can talk about customs. A certain custom prevailed in a society for a very long time, and maybe from that custom we got the inspiration and we thought that let's make it a law. Okay, that is also nothing but acts as a source. Like there is this custom of Saptapadi, you know, right? Saptapadi marriages.
Yes. Yes, ma'am.
Yeah. So Saptapadi is something like taking those 7 steps around the fire. So it is something which was followed like a custom only. Okay, but because it was so much prevalent amongst most of the Hindus, it got the recognition of law. Okay, Hindu Marriage Act says that if in your custom, in your tradition, Saptapadi is something which is followed, then it should be done. It should be done in a Hindu marriage. Okay, so it's nothing but from the custom, from prevailing custom, we got the inspiration and we added it in the form of law as well. Right, so those things also happen. In this context, it means cause of law. It may also mean, in its literal sense, the material from which rules or laws are known. It may be like if you talk about an act or a legislation, from where you will come to know what is a valid Hindu marriage, what are the essentials for that. All of that we get to know from the legislation that we have. Right? So it's a document or it's a legislation that we have from where we also get to know the laws. And just because we have a legislation, we can figure out what are the problems that this legislation is having, and we can try to make improvements on the legislation as well. So those things are also possible. So it is nothing but it also acts like an evidence of law. And in this sense, the expression sources of law is accepted in jurisprudence also. So when we talk about these laws, right, again, precedent, maybe previously decided cases are there, legislation is there. So when we want to know what is the law that prevails relating to a certain area or certain matter, we can simply refer to this legislation or refer to this precedent, and we will come to know what law prevails for that certain thing. India is a country that has abundant personal laws. Each community has its own personal law. Even though we say that, okay, this personal law is similar, there would be some variations depending on maybe the custom that prevails in a certain community or in a certain place. The Hindu, the majority community have separate family law. So have Muslims, Christians, Jains, Sikhs, etc. Hindu and Muslims have since time immemorial maintained that their laws are of divine origin. However, no such claim is made by other communities. So we say that from where these laws are coming, maybe from God. These where like a message, it was sent to the enlightened people, and then they told it to the common men, then we started following it, and just like a custom, it started to be followed, and finally today we have the modern sources that we get to see. So it is having a divine origin. It's not like how legislation works today. It's not like one day somebody passed it and then it became applicable, but these are having divine origin when we talk about the starting point of Hindu law. The modern Hindu law, by judicial interpretation and legislative modification, has undergone dramatic change, so much that any claim of divinity can hardly prevail. In some cases, the custom is still allowed to prevail. Even though we have written laws for most of the things, sometimes you will see that within the legislation itself, they say that this is what the general law is. But in case a certain custom prevails, then that custom should be given importance. Okay, so that thing is also there. Even though we have written laws, custom is something which still gets some importance. And when you talk about this divine origin thing, earlier it was considered that Hindu marriage is also nothing but like a divine union between men and women. Okay, but that concept gradually started to change. Okay, in Muslim law, it's considered that Muslim marriage is nothing but like a contract. Two persons agree to get married for a thing that it's nothing but like a contract. But in case of Hindus, it was considered like a divine unity and all that stuff. But later on, it was said that if it is divine unity, how come there is a concept of divorce there? So it is nothing but like it's in between. Okay, it's not like a divine thing also, it's not like a pure contract also. Okay, so we have seen that with this modern legislations coming in, with different judicial interpretations being made in different cases, that divine origin thing has slightly lost its uh, like importance, and it is sort of like a like other legislations how we have read. So it's not like a divine thing anymore, but rather it has undergone massive change with time, with different cases coming before the court. Okay, so these are the sources we have, ancient and modern. In ancient, we have Shrutis, Smritis, digest and commentaries, customs. In modern sources, we have equity, justice and good conscience, legislation and precedent. So when we talk about ancient or the traditional sources of Hindu law, it governs the conduct of Hindus in that particular time. The traditional sources of Hindu law is guiding principle in present system, also along with some modifications. So whatever used to prevail at that point in time, in that line only we have developed our legislations, we have developed our laws, but with modifications wherever it was required, those were also being added. So according to traditional sources of Hindu law, there are mainly four sources. First one is Shrutis or Vedas. Now, what is Shruti? Shruti, the word is derived from a word shru, which means to hear. Whatever was heard by those enlightened people, that is nothing but Shruti. Okay, so the term Shruti means what has been heard. It contains the sacred words of God, as if God, because they were meditating for so long, as if God explained them what should prevail, what should not prevail. It's like a message from God. That is why we say it is having divine origin. This source is considered to be the most important and essential source of all. Shrutis are the sacred, pure utterance that has been enshrined in the Vedas and Upanishads. At a later point in time, those were written down as well, right? And some things are there which the like the sages also forgot whatever they heard during the time of meditation. Once their meditation ended, certain things were there which they forgot. So whatever they could remember, they like wrote it down, and then it was given to other people also to be followed. So Shruti is something what was narrated by God. Okay, so they have a religious nexus with a person and help him in a way to attain the knowledge of salvation. It is considered to be the primitive source containing the knowledge of law. It literally means that which has been heard. So it's derived from this word which means to hear. In theory, it is primary and paramount source of Hindu law. This is from where law started. After that, we have seen modifications and developments, but this is like the basic start point of law. The synonym of Shruti is Veda. It is derived from the root Vid, which means to know. The term Veda is based on the tradition that they are repository of knowledge. All the information is written down, all the information is given there. So it's nothing but a repository of knowledge from where we are able to know details of what we should do, what we should not do. There are 4 Vedas, Rig Veda, Yajur Veda, Samveda, Atharva Veda. Some people believe that Vedas contain law and code of conduct, while others believe that law have been inferred from the Vedas. So we have derived it from the Vedas, and some people say no, it itself explains the laws because it tells us what to do, what not to do. So there are 3 parts which we see in each of these Vedas: Sanhita, Brahmin, and Upanishad. So Vedas provide the rights and duties, forms of marriage, requirement of a son for performance of religious duties, partition and exclusion of women from inheritance. But these cannot be regarded as clear-cut laws. Also, the society was divided in different varnas, and life was also divided into different stages. So based on that, we had different obligations, what should be done, what we should not do. Everything was explained in these Vedas. The concept of karma also evolved during this time. It was believed that a person will be rewarded as per his karma. Also, the concept of moksha was prevalent, which provided that a person could achieve salvation through knowledge and only through good deeds only. So all of these things was like the starting point wherein they claim that whatever we have heard, it's nothing but from God this message is coming, and people started following this as well. So now whatever was heard, that's nothing but Shruti. Now after hearing it, it's just those few people who heard it, right? Who heard those message from God. But now for other people to follow it, other people to obey it, what happens is it needs to be narrated to them. It needs to be told to them. That is nothing but smritis. So the word smriti is derived from the root smri, which means to remember, whatever we could remember. Traditionally, smritis contain those portions of shrutis which the sages forgot in their original form, and the idea whereby they wrote in their own language with the help of their memory. So whatever they could remember, based on that, they wrote it down. Thus, the basis of smritis is shrutis, but their human intervention is there. People tried to remember, recall, and then they started to write it. There are 2 kinds of smritis, Dharma Sutras and Dharma Shastras. Their subject matter is almost same, but the writing style is different. Like Dharma Sutras, it is written in a prose form, and Dharma Shastras, it's written in a poetry form, though sometimes we might see a combination as well. So number of Smriti writers is almost impossible to determine. There are many people who wrote it. Very important ones are like Manu, we see, right? We see Brihaspati. All of them contributed and they gave their own viewpoint that this is what is to be done, this is what is not to be done, based on whatever they like divine message they got, whatever they could recall. So the rules that were laid down in these smritis, they are divided into these three categories. And when we talk about this different sages who wrote it down, right, like Manu Smriti, it's very like an important source of law from where we get details of everything, right? Our duties, obligations, and all that stuff. But now we do not even know who this person was. He just imaginary, this is like a fiction name only he just gave, Manu. That's why whatever Manu could remember, we call it as Manu Smriti. So they did not like as such mention their name or their origin. It is called as he is like the first human being. Okay, Manu is considered as first human being, and that's why these textbooks, this religious text got that much of importance. So Manusmriti explains all of what we should do, what we should not do. So it does not define a code in India, but also it is prevalent in various other countries also. So this is having like a importance, like a divine origin. This is having importance. So it explains all the details about what duties and obligations of a person is based on his age, based on his status. All of that is explained there. It is compilation of all pre-smritis and gathas. Manu was a Brahmin who explained whatever he could remember and he wrote it down. But he did not give that much importance to women's rights or to the Shudras. But even then, his writings or whatever is explained in Manusmriti, that got very much importance in terms of development of laws. Okay. Then we have digest and commentaries. So when we talk about digest and commentaries, it's the third most important source of ancient source of Hindu law, which is written by various authors of Hindu law. So digest and commentaries are written by various authors of Hindu law. Commentaries and digests have expanded the scope of Hindu law because their explanations or their opinions were also added. So it broadened the scope of Hindu law, and also it brought some differences within Hindu law only. A few differences are there relating to certain concepts. Even though same laws are applied, differences we get to see. It played a very major role in developing the very concept of Hindu law. Commentaries refer to expansion of Smriti in a simple language. The concept of digest came into existence after the commentaries, and they mainly explain the matter of Smriti with contradiction. So different writers wrote their viewpoints, and there were contradictions in that. There were differences in that as well. A large number of commentaries and digests were written by our ancient authors on various smritis. One of the most important digests is Jimudvahana's Dayabhaga, on the basis of which we have this Dayabhaga school of Hindu law, which is more applicable in Orissa, West Bengal, Assam, and those states. Then we have Mitakshara, which is applicable in other parts of India, which is also based on these commentaries only. So on the basis of these differences that are there, we have these two schools which existed based on the explanation or based on the differences that we have. So the main objective of these texts is to gather the scattered materials available in the form of smritis and shrutis and to compile it in a more comprehensive form for betterment of the society. So the things are written down very clearly, what applies, that we get to see. With that purpose, it was written down in one at like one place. Thus, these have very much logical, and these were very much logical, and it helps us to understand what is the law applicable in a certain part of the country. Okay, so these are nothing but like explanations or further recommends being made on the shrutis and smritis, and based on that only we see like the schools, development of schools is nothing but a result of this source itself. And then talking about customs and usages, this custom and usages legislation and also precedent, right? All these are like sources which we commonly see for any sort of laws. So whatever laws we talk about, customs and usages, we get to see as a source. So custom is an important source even for Hindu law. It refers to those traditions or those activities or practices which people are following for a very long time, and over time they receive the force of law. So people from a certain part or certain territory, they might be following some traditions or certain activities might be common in them. So it is followed for such a long time without any sort of questioning or without any sort of like nobody stopped them in between. It was followed for a very long time. So because it was followed for a very long time without anyone questioning it, it just after a point it gets the force of law only. So it becomes just like a law, it is being followed. The main objective behind this source of law is that if the people are following a particular custom and it does not possess any harm to the society, then the state should recognize them legally. So if that is helping the people to deal with a certain matter or deal with a certain situation, and as such, it's not having any problem, right? Society has not faced any issue because of following that custom. Nobody has questioned it also. It's being followed for a very long time. So in such cases, after a point, it would be recognized legally. It gets legal recognition also, it's being followed. Now when we say legal recognition, it might be like that saptapadi thing that it's added in law in itself, that this will be followed or this should be followed. Or sometimes we see that law will tell you a certain thing, that this is what will apply, but if there is a custom prevalent, that custom should apply. Like that also we get to see. Okay, like we have this act, Transfer of Property Act, which talks about different modes of transfer. Okay, different modes, how we can transfer a property. There we have concept of gift also. Okay, so we can transfer a property by way of gift as well. So under that legislation, it says that these provisions relating to gifting of property, it applies to everyone else, but not to Muslims. Because under Muslim law, they already have a provision called hibba. Okay, like how gift will be made. So they already have a provision. As in, if you already have some customs or some usages prevalent, that is given importance sometimes under law also, that if there is a custom prevalent, you can do it. Relating to adoption also, we see if there are customs prevalent, that would apply. Like under Hindu law, it's well recognized. Under other laws, it's not recognized like that. Muslim law, Christian law, but it again says that if there is a custom or usage prevalent which allows you to adopt a kid, then in such cases you can do it. So that's nothing but giving it a validity of law. So customer usage is an important source of Hindu law, and some of our ancient Hindu scholars put it at ahead of written laws also. That is even prevalent today, even though we have written laws, sometimes customs are given importance. So there was this case wherein it was held that clear proof of custom will outweigh the written text of laws. This applies even for adoption also. If you can give clear proof that this certain custom prevails, then that would override the written laws also, if written law has allowed for it. Like if a Muslim wants to adopt a kid, they can prove that under our custom adoption is allowed, and the person will, that adoption itself will be considered as valid because he could prove the custom. So proving it is necessary that this certain custom prevailed in our community or amongst us. When we talk about customs, there are three types. General custom, which refers to those practices that are followed throughout the country, maybe a custom prevalent amongst Hindus. They are not restricted to a particular geographical area as such. It might be a custom which is followed by all the Hindus, by all the Muslims, like that. When we talk about local customs, it refers to those customs which are only found in a particular area of the society. It might be a certain community in a state, only they follow it. So that's nothing but local custom. It is just locally followed, not like everyone in the country is following. Then we also have class custom. It includes those customs which are followed by particular class of the society. And also we have family custom, which includes those customs which are prevalent in a particular family. So they can be easily abundant as compared to other forms of custom because it's just something which is followed in a family. So it's not something that the court would give that much of importance or priority as compared to the other types of customs. Now, what custom is, there we have like debates and discussions, because as such, if we talk about written laws, it's there, we can see it, right? If you talk about shruti smritis, that is also fine. But when we talk about custom, whether it is a custom or not, whether it's a practice that people started following just few days back, there those things also need to be seen. Okay, so there are certain grounds that we can see in order to decide whether a certain custom is valid or not. First of all, antiquity. The custom shall be in practice from time immemorial. Though a period is not specified, it is believed that something which is followed for at least 40 years or more, that constitutes something which we can say it is being followed since time immemorial. For a very long time, it's been followed without any sort of restrictions in between. It is continuously being followed. There we can say that it's a custom. We have reasonability. The practice in question shall be reasonable and there shall not be any arbitrariness. Now, when we talk about customs, it should be reasonable also. It should not happen that a very bad practice we are following and now we are saying that it is our custom, we should be allowed to follow it. That will not happen. Okay, like sati. Sati was also prevalent. Like a custom only, it was being followed. Nobody questioned it. It just continued. So we cannot say that just because it continued for such a long time, we will continue with it. There has to be reasonability also. If not, a legislation was passed in order to get rid of it, right? So we can get rid of bad customs by way of passing legislations, and same ways a proper valid custom can help us in introducing a law also. Okay, so whatever good customs prevail, those are sources of law, those help us in bringing new laws. But when we talk about bad customs or evil practices, we need to get rid of it, and there again law helps us. Okay, so reasonability is very much required. Then continuance. The custom and practice shall be continuing in nature since its emergence. It should not happen that it was followed for 2 years, after that there was 3 years gap, after that again it was followed for 1 year, then 5 years gap. That should not happen. It should be something which was continuously followed from the time it started. Plus, there should be certainty. A valid custom shall necessarily possess the element of certainty. What the custom is, we should be able to tell it very clearly, right? So, certainty has to be there. It's not like you can do like this also, that also. Some custom we follow, that should not happen. Certainty is required. Not against public policy. So, a custom should not again be against public policy. Like I said, child marriage, sati system, dowry system. A person cannot say that dowry system is a custom, we follow it. So that should not happen because it goes against public policy, it goes against the established law. So that should not happen. Okay, so these are the traditional sources of Hindu law which we have. This part is clear, right?
Yes, ma'am. Yes.
Talking about modern sources of Hindu law, it refers to those sources which are like new sources that have emerged now, and these are very commonly seen in today's time as well. So, what are these sources? First of all, we have concept of equity, justice, and good conscience. Now, this is something that you get to see when you read different cases and decisions. Also, there also you would get to see that we applied the concept of equity, justice, and good conscience. Now, what is equity, justice, and good conscience? Sometimes Sometimes it may happen that we have a written law, we have a written legislation. Okay, but that legislation, if you try to apply, right, that legislation is not doing justice to the parties. Okay, so judges might see that there is a legislation, but that legislation is not doing justice to the parties. That, like this, okay, equity. We need to do equity. It might happen that if we try to apply the legislation, it says that give everyone the same thing, but that's not providing justice to the parties, right? If this kid goes to the court, he is not getting justice. So court will try to apply the principles of equity, justice, and good conscience, and court would say, how can we provide justice to the parties even though we are applying the same provision? Might be this is a provision that you can give stools, so giving stools is like a provision. Now how many we should be giving to whom, that's nothing but we need to decide. Okay, so maybe this person was given one, that justifies he is able to see the match, this one is given to, as in we are making some changes in the laws in order to ensure we are doing justice. Okay, so this is nothing but equity, justice, and good conscience. That there may be certain times wherein you don't have a written law, or might be written laws are not doing justice. In such cases, judges would try to apply their mind, and judges would try to give a decision which is best in that given situation. Okay, so this concept of law is based on the principle of fairness and impartiality. Law should not be impartial, it should be fair to everyone. People should be able to get justice under a law. Many times many times the judges face a case in which there is no legal remedy for the aggrieved party. Maybe we don't as such have a law to provide a remedy to the parties, but judges know that yes, this party has suffered. Okay, however, remedy is not given. The party will suffer considerably if even after coming to the court he is not getting any sort of relief. Right? So in such cases, in the judges are having a responsibility to do justice by applying the principles of equity, justice, and good conscience. So under this principle, court can provide appropriate relief. Whatever best court can do in that given situation, court will try to do that to the concerned party on the ground of reasonableness and fair play. What is justified in that given situation, judges will try to do that. Okay, like there was a case you will get in contract law. Okay, so what happened in this case is, otherwise we say that minor is not entitled to enter into a contract, right? We should be above 18 years to be entered into a contract. And in case a child enters into a contract, what will happen? Will that contract be valid? Minor entering into a contract?
Maybe in general sense it is not there. In some exceptional case, may we hold good.
Okay. So when we talk about contracts entered into by minor, Because Indian Contract Act specifically says minor cannot enter, it is called as void. Okay, void ab initio, as in it is void from the very beginning, as in court treats it like as if this contract never existed. The moment it was entered, from that moment itself it was void, even though maybe case was filed 5 years later. Okay, so this is what it is, that if a child enters into a contract also, it's void of initio, and child will have no obligation under that contract. Okay, whatever the child said, whatever terms or conditions were there, none of it the child needs to follow. Okay, if child has taken some money also under a certain contract, that also he is not supposed to return, because it's as if this contract never existed. Okay, so it's similar to those contracts which we enter, those agreements that we enter, accepting a dinner invitation. It's as if it never existed for the courts, right? Same ways this also is treated. Contracts entered into by child, and child would have no obligation. Court will not even ask them to return the favor that they have taken. But now what happened is, there was one case which was filed. Okay, there was a contract. A child entered into a contract with another person, wherein this other person was a major person with knowledge of minority, as in he knew that the other party with whom I am entering into the contract is a minor person. Even after having knowledge of minority, he entered into the contract, and later on the child said that I'm not performing my obligations because I'm a minor, I'm excluded from it, I'm not performing. This major person went to the court, and court said that you don't have any remedy, because contract with a child is anyways void of initio. Why did you enter into the contract even after having knowledge? You don't have a remedy. But there was another case, similar case, okay, wherein what happened is that there was a child who entered into a contract with another person, that's a major person, but this major person was not having knowledge that he is entering into a contract with minority. This child represented himself to be a major person, so this other one did not know he is entering into a contract with minor. So child took some amount of money from this person, and then he said, I am not performing my contract, I am not even returning you the money, I am a minor, I am not responsible. Okay, so when this case was filed in court said that yes, in general, these contracts are void of initio. It's not binding. Minor is not having any obligation. But if we try to apply that principle over here, it would not be justified, right? Because the child himself represented, he tried to take advantage of this provision of law, and if we release him like that, he is going to do it again and again. Other children also would be doing it again and again. So in such cases, justice and equity would not prevail, right? So in this particular case, child was not made liable, but in this case, court said that even though you are a child, we cannot ask you to perform the contract, but we can ask you to return the money that you had taken under the contract. Okay, so this is nothing but equity, justice, and good conscience. Even though we have a clear law mentioned under Indian Contract Act that such contracts would be void of initio, sometimes judges can apply their mind in order to see, or in order to ensure that they are not doing injustice to the parties. That is nothing but equity, justice, and good conscience. What is right in a given situation? So this is similar to the concept of natural law that you will get in a subject called jurisprudence. It says that law originates from our inherent tendency of differentiating between right and wrong. So judges also are in a position to differentiate between what is right and what is wrong, and from there only it has come. Okay, so it's similar to that natural law concept. So whenever a conflict arises between natural law or codified law, that codified law says that minor's contract is void of initio, it's not valid. But when we try to apply it in the given situation, it's not giving justice. As in, there is a conflict over there. In such cases, natural law will prevail and will guide our actions as a source of Hindu law also. So, what would provide justice? Based on that, many a times cases are decided by courts. So, wherever conflict arises in interpretation of Hindu law, this principle is used by the courts either to formulate new laws or to carry forward the existing laws. Equity, justice, and good conscience may help in formulation of new laws also, or might be in applying the existing laws, like that example of contract. Law was already existed, but it was applied in a different way by applying equity, justice, and good conscience. Many times when you read a judgment, you will see that we tried to apply principle of equity and then we are giving this decision. Like that also, judges try to justify the decision. Okay, so is it clear, equity, justice, and good conscience?
Yes, ma'am.
Another source that we have is legislation. So So, what is legislation as a source? What is legislation?
Legislation against set of regulations.
Yes, it may be rules, regulations, acts, etc., which also play an important role in terms of laws, right? So when we talk about Hindu law, there also we have various legislations. So legislations often regarded as a tool for social change. The legislation provides a base and authenticity of the law. Everything would be clearly written in the form of an act, so it gives an authority of law. We know what is the law, what is not, once we open a certain legislation. So a lot of matters, for a lot of matters, codification of personal law was attempted by way of introducing different legislations. Okay, so after codification, any point dealt with by codified law is final. Once something is specified in the legislation, that would be final. Like we have Hindu Adoption and Maintenance Act. Whatever provisions are said there, that will be considered as final and binding over there. Okay, so for different matters, we do have provisions like Hindu Marriage Act, Hindu Succession Act, Hindu Minority and Guardianship Act, Hindu Adoption and Maintenance Act. All these are nothing but codified areas of Hindu law wherein we have a legislation clearly specifying what would apply and what will not in a certain given situation. So Parliament is having the power to bring new legislations in accordance with needs of the society and also to constitute new laws. For example, a new way of performing Hindu marriage in Tamil Nadu that got rid of rituals and priests was rejected by Supreme Court on the basis that new customs cannot be invented. Whatever prevailed as a custom, that should continue. New custom should not prevail. That was the viewpoint of court. But Tamil Nadu later passed an act that recognized these sort of marriages. So by way of legislation, we can bring whatever new things we want to introduce. But that's not possible by way of custom, because custom recognizes what is being followed for a very long time. So we cannot introduce new customs as such, but yes, with the help of legislations, we can bring those new changes or new things over us. Now, talking about precedence, which is the last source that we get to see in Hindu law, it is the last source and the modern source of Hindu law. Okay, so what is precedent? Ishita, do you remember from jurisprudence class?
Yes, ma'am.
Sources of law we saw, right? So what is precedent?
Precedent is basically which is binding on which is based on hierarchy of course.
Sorry, which is?
Based on hierarchy of course.
Based on hierarchy, of course, yes. So what will happen based on hierarchy of courts?
It is binding on lower court.
Yes, binding on lower court. Based on hierarchy, binding on lower court. So what is binding?
Decision given by superior court.
Correct. So precedent is nothing but decisions given by superior courts will be binding on inferior courts or the lower courts or the subordinate courts. Now what happens is when a case is filed, the judges, the advocates, everybody puts their all their effort. Cases are decided after years altogether. So once a certain thing is decided, once for a certain matter, everybody has put their effort and matter is decided. It should not happen that again, if tomorrow similar matter is coming, same energy, same effort is wasted there. Rather, what we can do is we can follow whatever was said in the previous case. All right. In order to establish that, we have this concept called precedent. As in, once something has been decided, let the lower courts follow that same decision. If there is no error in the decision, that same decision should be followed. Okay, so after establishment of British rule in India, hierarchy of courts was also established that some courts would be superior, some would be inferior, and then inferior. This system was also being established. And this doctrine of precedent is based on it only that decisions of higher courts would be binding on the lower courts. Now, if you talk about Supreme Court, today we see that Supreme Court's decisions are binding in all courts in India because it is apex court. When we talk about high courts, there are 25 high courts in India. So what happens is high court's decisions would be binding on its subordinate courts. When we talk about High Court of Karnataka, its decisions are binding on all the subordinate courts in Karnataka. But it's not binding in Punjab or Madhya Pradesh or some other state. Like if High Court of Karnataka has given that decision on hijab, right, that you should not wear hijab to the classroom if uniform is being prescribed. That decision should be followed by all the subordinate courts in Karnataka, even if the judge is against that viewpoint, even if the judge feels that no, they should be allowed to wear hijab, then also they need to follow it. That's nothing but precedent, the binding force which is there. And this concept is called as precedent, that whatever higher court has said, we need to follow it without, even though we do not agree to it. So Supreme Court's decision binding on all courts, High Court's decision would be binding on its subordinate courts only. Whatever Karnataka High Court has said, it will be binding on the subordinate courts in Karnataka, not in some other state. But when we say it is binding, it's not like it would be binding forever. There are possibilities of changing decisions also if there was something wrong in it. Like if Supreme Court today says something, we can alter that decision of Supreme Court at a later stage if required. Okay, only thing is that number of judges who decided the case should be higher. Like if 3 judges gave a decision, it can be altered by maybe 5 judges, 7 judges, and not by 1 judge or 2 judges. It cannot be altered by a lesser number of judges. Okay, so this is nothing but what we call as precedent, that judgments given in previous cases will be followed in the cases which are about to come. And because we are talking about a judgment when we talk about precedent, there are two important parts that we get to see. In a judgment, there are two important parts that we get to see. That is nothing but ratio decidenty and obiter dictum. So do you remember what is ratio decidenty, Ishita?
Ma'am, actually reason for decision. Why this is decision was taken and how is it useful for future generations.
And obiter dicta?
Obiter dicta is the general observation by the judge.
Yes. So when we talk about ratio decidenty, it's the reason why a certain decision has been given. Even though they are judges, they cannot say that I felt like giving this decision, so I am giving. Or without any explanation, they would not give the decision. Okay, if you look at any judgment, you will see that while giving the judgment, judges will try to justify why this decision is given. They might say that we have this certain legislation under which 7 years of punishment is given, but the crime that this person has committed is not that severe also, so we are giving 3 years of punishment, because in similar situations, in this certain case 3 years punishment was given, in this certain case maybe 2.5 years was given. Like that, they would try to justify. Okay, they might give a lot reference of a lot of cases also, that in this case this happened, in this case that happened, under this legislation this is the provision. All those grounds would be mentioned, and after that finally they will give the decision. That's nothing but justifying the decision which they have given. And this ratio decidenty becomes very important. This is what we follow in the upcoming cases. Okay, in the next cases also, the judges are going to rely on ratio decidenty only. So that is a very important part in the decision. There is one more part which is obiter. Okay, so there is this other part which is nothing but obiter dictum. Now, in actually this we have codes, right? Code of civil procedure, code of criminal procedure. They even explain what all things should be mentioned in the judgment. So, apart from many other things, these two are very important parts of a judgment. Okay, so ratio decidenty is the reason. Apart from that, there is one more part which is obiter dictum. It means the opinions. Okay, sometimes it may happen that judges are deciding on a case, and they are deciding on this case for the last 4 years. All right, so what happens, a lot of matters relating to that area they come to know, they see it, they might have some opinions or they might have some comments of their own regarding it, right? So those comments or those observations made by judges are called as obiter dictum. Maybe they are deciding a case on child labor, or maybe they are deciding a case on they are deciding a case on child labor, wherein they have given a certain punishment because of that certain crime. And while giving that decision, they might mention that because of child labor, school dropout rates are also increasing. So what we need to do, we need to introduce free and compulsory primary education. Okay, there it would be obiter dictum, wherein judges are saying that because of child labor, school dropout rates are also increasing. Okay, so as such, that statement or that observation is not binding, but it might have some importance, because based on those observations, maybe we would have a legislation providing for free and compulsory education. Like that, it happens. Sometimes while giving a decision, court might say that police officers are not behaving in a very like they are not very much concerned about the pain of the victims. Maybe we need to introduce some workshops or awareness programs which properly trains police officers how to speak to victims. Okay, so that is nothing but an observation made that maybe it's needed that some awareness programs are being introduced so that police officers are properly trained on how to handle a certain situation. That becomes an obiter dicta because it's just an opinion or observation made by the judge. As such, it's not binding like ratio decidendi, but it's still having some importance. Okay, so this part is important. Actually, there are like two parts in a precedent, ratio decidendi, and obiter dictum. Is it clear or confusing what these two different parts are?
It's clear, ma'am.
So this reasoning part is what becomes binding in the next coming cases. So when we talk about Hindu law, also precedent is an important source of Hindu law. When legislation is not able to secure the ends of justice, precedent comes into picture and serves the necessary purpose. When there is no legislation, there might be certain situations when legislation is not there, or might be legislation is silent on a certain area. If case is filed, their court can give a certain decision, and that decision becomes binding like a precedent. It becomes binding in the future cases. Okay, so there was this case which is very famous, not relating to Hindu law, but in general, relating to precedent, Vishakha versus state of Rajasthan. Okay, she filed a case relating to sexual harassment of women at workplace. And when this case was filed, we were not having any legislation to protect or to deal with this problem. Okay, so in this case, Supreme Court gave some guidelines, detailed guidelines were issued that these are the things what you need to do. This is what employers should do. You need to establish a sexual harassment cell there so that if somebody goes through something like that, they can get some guidance. All of those guidelines were being mentioned. Okay, and those guidelines were being followed like a precedent. It became binding like a law also, until and unless we had a legislation to deal with this issue. Okay, so that is that much importance precedents are having, not just in the upcoming cases it will be followed, but also these guidelines becomes applicable to us just like a law. So there was this case wherein Supreme Court observed that precedents have become an integral element of Hindu law. They have modified and supplemented Hindu law as per needs of the dynamic society. Sometimes you may have written laws also, you may have legislations also, whether you talk about Hindu law or other laws. But might be legislation, in the legislation, a certain provision is there, but the provision is not very clear. It needs explanation. It needs it needs to be further elaborated. In such cases, also judges would come, they will elaborate it, they would give further explanations, and that explanation or becomes binding like a precedent. So these things also help in widening the scope of the laws which we have. Okay, there is something called as Article 21 of Constitution, which talks about right to life and personal liberty. It was courts who added a lot of other things also within Article 21. So that's nothing but it just becomes binding like a precedent. It becomes binding for all the upcoming cases. If today court is saying that right to internet, right to access internet is also something which is a part of right to life, then in the next cases that should be followed. Okay, that thing becomes binding. So this is nothing but what precedent is, that decisions given in a certain case will be followed in the upcoming cases by the lower courts. They cannot make changes even though might be they are not in favor of that decision or they do not approve that decision. Still they need to follow it. Okay, this part is clear, right?
Yes.